Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Today, we want to talk about a substitute teacher who may have killed somebody, but still wants to be responsible. Let's talk about Aaron Hernandez and abatement ab initio. And just when you think the Chicago Police Department was getting some good press, did they go and mess it up? Let's talk about it. So the first case on the docket tonight involves a school teacher in Georgia accused of murder. He's had kind of a rough week, but it's nice to know people still like to be responsible. So Mr. McClendon had been volunteering, or I guess had a second job at his church, and was the chief financial officer. As it turned out, he wanted to liberate God's money and stole an estimated $103,000. Now, he is presumed innocent, so we will give him that presumption. But Mr. McClendon was kind of having a bad week. But it wasn't all bad, because the school that he worked at as a teacher said that he could still teach pending these felony charges for theft. But Mr. McClendon was in a relationship, and his partner, a Mr. Jones, they'd had some rocky days over the relationship. Mr. McClendon accused Mr. Jones of having an affair with another gentleman, and the police were ultimately called for kind of a domestic dispute, but no one was arrested, and that was the end of it. However, 2 days later, Mr. Jones is found shot dead in his apartment complex at roughly 5:30 in the morning. Now, Mr. McClendon, being the responsible individual that he is, either A, wanted to make sure he had some sort of an alibi by saying that he was sick, or B, he is the most responsible murderer in the world and wanted to make sure that his students had a substitute teacher for the day. You decide. Now, the second case on the docket today involves the deceased New England Patriot / convicted murderer, Aaron Hernandez. As most people probably may recall, and if not, I'll fill you in on it, Aaron Hernandez played for the New England Patriots. Usually, that in and of itself would make you to be a despised man, except maybe in the New England area. But Mr. Hernandez, always trying to push himself to be the champion that he was, tried to excel at murder, and he was accused of 3 murders, and he was convicted in one case of killing Odin Lloyd. Now, he was ultimately found not guilty of killing 2 other individuals, and while he was incarcerated and his appeal was pending, Mr. Hernandez killed himself in custody. Normally, what takes place in the legal system, and I have seen this myself several times when a client has died pending an appeal, but there's a process or legal theory called abatement ab initio. And what that means is that if you die pending appeal, that your judgment and conviction is not final, and therefore the conviction does not enter. It is erased. And the person that was convicted at the trial level, although the judgment is not complete, has his record cleared. Well, that's what people were hoping for Mr. Hernandez. But the state basically groveled, and it was somewhat articulated that the prosecutors in this particular case couldn't open the door without judicial assistance, basically allowed the judgment to enter, even though the appeal was pending. It goes up to the next layer of courts, not the ultimate Massachusetts Supreme Court, but their Court of Appeals, and they say, yes, we are going to create a new law, a new standard here, and that if you die because of this old and antiquated thinking that we've had for many, many years and hundreds of years, it's no longer any good. And instead of making that effective as of the date of the order moving forward, the court basically made it retroactive back to Mr. Hernandez's case, and therefore the conviction will enter. Mr. Hernandez, although convicted of murder, hadn't been cleared or had not had his conviction finalized. Mr. Hernandez got screwed. Now, let's talk about the Chicago Police Department on the docket this evening. Just when you think they were getting it right, just when you think they were going to get some good press, no, there's always that one guy that has to screw it up for everybody. And in this particular case, it's actually two police officers. And what had happened is a student who was asked to leave her classroom because she was communicating on her cell phone. And I'm not sure I'm going to pronounce this name correctly, but her last name is Howard, Miss Howard. But her first name is Digma. And I'm assuming that's common spelling, D-N-I-G-M-A. Well, there's surveillance video showing the officers basically dragging Miss Howard down the stairs. Then there's now surfaced cell phone video that shows the officers threatening to tase, but also shows Miss Howard slapping at or potentially biting or grabbing the police officers, and the officer puts their leg on Miss Howard. As you can probably imagine, like all things in life, and if you watch the video that I've previously made about everything I needed to know about life I learned as a criminal defense attorney, one of the most important rules, and probably the number one rule, is it's always about the money. All right? Miss Howard, not just wanting her name cleared, she wants financial compensation. She has already sued the police department, the police officers, and the school district. We will see how this case goes. I don't believe that Miss Howard will be receiving a smallette, even though Cook County, Chicago seems to be the place of restorative justice. We will see if either A, Miss Howard receives some restorative justice, or B, the cops get a pass as well. Not saying the police were wrong, not saying they were right. 16-year-olds should probably listen to their teachers, and so they don't have to be sent to the school principal, and it certainly shouldn't involve the police. I don't know about where you went to school, but we didn't have police officers in my school growing up. We are starting a new segment here on Crime Talk called Ask Scott. And if you leave a question below, we will try to answer it as long as we are legally and ethically permitted to do so. And well, frankly, and if it's just not too gross, we will ask that. Some of the questions I can tell you that I have been asked are, what was the craziest person you may have ever represented? Well, I can tell you. The individual had some mental health issues. He was the only person who thought that he was completely sane and thought that he was basically an agent for the CIA. I attempted to contact the CIA to see if he'd ever worked for them, and they were unable to find his code name, Secret Squirrel, in their books. So always remember, it's always the crazy clients that don't want to go for psychiatric evaluation. The clients that are faking it, that want to go be evaluated, are completely sane and competent. Another question I always get, and this is probably something I used to get from my mother-in-law years and years ago, but have you successfully defended someone you knew was guilty, and how can you sleep with yourself at night? I can tell you, I can sleep like a baby. Yes, I have represented people where I thought that they were guilty, but that the state has failed to prove their case beyond a reasonable doubt, and either charges were dismissed or the jury found them not guilty. But understand, I've talked about this previously, it's not about the defense counsel. If the defense or the defendant wins their case, yes, it may be because they're absolutely innocent, or two, the prosecution failed to prove their case beyond a reasonable doubt. Also, I've been asked several times throughout the comments, what has made you the most proud in your career? Probably it was a case where I truly believed my client was innocent. He was looking at spending the rest of his life in prison. He maintained his innocence. He was a professional. I did everything in my power to convince the district attorney that my client was innocent and she should not believe the complaining witness, that her story just simply did not make any sense. And the district attorney dismissed me, said, I believe the complaining witness, let's go to trial. I don't think she'd ever watched the video. I don't think that she had done anything until trial prep. We went to trial. We seated the jury. The prosecution called the complaining witness. I cross-examined the complaining witness. Did pretty well, I might say so myself. Came back from lunch, and I had a motion to dismiss the entire case sitting on my desk. The district attorney finally paid attention and realized the story made no sense. That was probably one of the most proud and happiest moments I've ever had, because I truly believed I had an innocent client, and it turned out to be so. So ask your questions, leave them below. We'll try to answer them. Also, today in history, what comes to mind? Jesse James. Some people may wonder, hey, isn't that guy that married Sandra Bullock and builds cars and motorcycles? No. Jesse James. Isn't that an adult film entertainer? No. We're talking the original bad boy, Jesse James, the guy that used to rob banks with his gang. Well, today in history, he robbed a bank in Columbia, Kentucky. And as a good old bank robbery used to go back in 1872, only one person wound up dead, and Jesse James and his gang got away with $1,500. There were no surveillance cameras. There were no dye pods that went into the bags. The good old days. All right. Once again, thanks for watching. Be sure to subscribe. If you haven't already, check out our links below for merchandise and all our links to Facebook, Instagram, and scottreisch.com. Thank you. We'll see you next time.